Welcome Till Death Do Us Plan, the podcast where love, life, and legal planning all come together.
We're your hosts. I'm Santos Vargas.
And I'm Patty Vargas. We're both attorneys and husband and wife.
Each week, we'll tackle the real conversations people often avoid, from estate planning and probate to prenups, postnups, and everything in between.
We're here to help you plan smarter, protect what matters, and feel more confident about your future.
Because life is unpredictable.
But your plan doesn't have to be.
Let's dive right into it. Hello, everyone, and welcome to Till Death Do Us Plan. Now, today we're going to be talking about living together, dying apart. What does that mean? That means estate planning without the ring, without being married. Can you do it? Should you do it? Patty, why don't you go ahead and lead us off?
I think this really is an important subject, especially given how many couples these days do live together, and whether they're engaged or not yet engaged, but just live together. And circumstances can often arise that leaves one of those individuals not only heartbroken with the passing of their loved one, but also perhaps in circumstances that they could never have imagined. So if you think about it, if one of the individuals in that couple were to get into an accident, the other individual is not going to be able to make medical decisions unless the person has executed a medical power of attorney, which can be hugely important, especially if the default individuals are not individuals that you would want to make your medical decisions for you. And so it's critical that those lifetime documents that we've discussed before, medical power of attorney, HIPAA authorization, an advance directive, and a statutory durable power of attorney be executed where you are naming that partner as your primary agent. They're the ones that you live with. They're the ones that you love. They're the ones that I would anticipate you want making those really important decisions.
So if you have a longtime partner, you're not married, and you talked about who some of the default people would be, right? Let's say you're in an accident, something happens to you, you're not in a position to make your own medical decisions. Maybe you want your long-term partner to be able to make those decisions, but the law says that it's going to be this default person that makes those decisions instead. Who are we talking about? Who are some of the default people in different states?
So there are default people, but also what we're talking about is a guardianship or conservatorship. And typically each state is going to have a list of individuals that have priority to serve as your guardian. And not in there is, at least not high up on that list, is a partner. Instead, what you'll find is a spouse. And if you're not legally married, then your partner does not count as that spouse. So it's typically a spouse. It's typically an adult child. It then oftentimes is a parent. And so you can execute a document in which you designate your partner as your guardian in the event of future need, because that, in fact, is the first person who would get to serve is your partner. But you must execute that appointment of guardian in the event of future need.
So let's say you have a situation where you have a couple of adults, maybe they have grown children, and the partners are very close to each other, they care for each other, they just happen not to be married, and something happens to one of them. And that person's then not able to make their own medical decisions. If they've told their longtime partner what they hope happens to them in the event that they get in an accident, aren't they protected? Can't the partner just go in and talk to the people at the hospital and let them know what the wishes of their partner is?
They can certainly try, but there's no legal basis for those medical providers to listen to that partner. Instead, what I would anticipate is that the medical providers are going to start to ask for, does this person have a medical power of attorney? And if not, they're going to want to know who the next of kin are. And sadly, just as a partner, even if you've been in this long-term committed relationship, you will not qualify for that person as being next of kin.
So what I'm hearing is that even if you've told your partner your wishes in the event that you get hurt, or maybe you're incapacitated, you can't make your own decisions anymore, what you're saying is that's not good enough. You really need to fill out the right legal documents to make sure that that person has the authority to make those decisions for you.
That person, your partner, needs the legal documents, the legal authority to act on your behalf. And without those, other individuals have the ability to step in and circumvent what your partner is advocating for you on your behalf, and instead maybe advocating in a way that does not benefit you or your partner.
Now, what are some of the documents that will give a partner the authority to make decisions on behalf of their longtime partner?
Sure. Again, the documents that come to mind are a medical power of attorney, where you name your partner as your agent and who will make your medical decisions if and when there comes a time because of illness or injury you are unable to communicate your medical decisions. I would also recommend that you name your partner on a HIPAA authorization in which they are able to speak to your medical providers, particularly if you are in an situation where you are unable to communicate your medical decisions. And if you're so inclined and you want to execute an advance directive, also known as a living will, that talks about the type of care or treatment you would want if you're in an irreversible or terminal condition, that you execute that. And in those states that require you to name an individual in that advance directive, that you go ahead and you name your partner in that document.
So let's say we have two people that have been living together for a very long time. Nobody questions it. They're partners. The community knows that they're partners. Their children know that they're partners. They know that they love each other, that they live together, that they share their finances together. They just happen not to be married. In that situation, if something happens, if one of those partners dies, is the other one protected?
I would say that it depends, which I know is probably a phrase that lawyers love to use, but in reality, it really does depend. And I say that because it's going to depend on several things. It's going to depend on whether or not that deceased individual has named the partner on their beneficiary designation forms as a beneficiary under a life insurance policy or their retirement plan. It's going to depend on whether or not they qualify for what might be referred to as an informal marriage, or also known as common law marriage. In Texas, to have a common law marriage, you have to have three things. You have to live together, which is usually the easiest to prove. You have to hold yourselves out as husband and wife to other people. So when you go to a party or you're being introduced to somebody for the first time, you would say, so nice to meet you. This is my husband. This is my wife. And then the third is that you have an agreement to be married. And that is probably the most difficult element to prove when you are trying to prove that you are common law married, especially if there are other individuals who want to come in and argue that there was no common law marriage, there was no informal marriage, that there was no agreement to be married. Because if they're able to do that, it's possible that the surviving partner in that relationship is going to be cut out because of the way in which the laws of intestacy will work in the event that the deceased partner does not have a will.
Okay, so let's say that they're not married. There's no question they're not married. They haven't satisfied the factors for common law marriage. Are there other ways besides beneficiary designations for one partner to protect the other in case one of them dies?
Sure. Easiest thing to do is to have a will and name that person. I know in Texas there's no forced inheritance. In other words, I could leave my assets to whomever I wish. I know that's hard to believe, but even though Santos and I are husband and wife, I'm able to give my community estate to whomever I want. I'm able to give my separate property to whomever I want.
Good to know.
But what?
Good to know.
But the truth of the fact is that when you have a situation such as this, where you have a committed couple, where they want to ensure that their partner is protected, having a will in which they name them as the beneficiary is huge. But let me say this. What about a situation where you have a couple that's together and they have been together for a long time, but they don't intend to be married? In other words, situations where someone is claiming common law marriage.
So, Patty, let's talk about the term, and a lot of our listeners and viewers may have heard this, cohabitation agreements. Can you explain a little bit about what those are, how they work, and why it is that a couple, even though they're not married, might want to think about whether or not that type of agreement is right for them?
Sure. So we've been talking about couples who are committed, who are really almost married, but just haven't, had that formal marriage solidified. However, if you're in a situation where maybe you are living with someone and you have been living together for some time, but you don't consider yourself to be married, it might be really important to have a cohabitation agreement in which you say definitively, we are not married. And why is that important? Well, that's important because if you don't have a will that's already leaving your assets to certain individuals, that person with whom you're living with could argue upon your death that you were married and that they are entitled as a surviving spouse to certain rights and to certain benefits. But with a cohabitation agreement, you're able to say definitively, we are not married. We have no intent to be married. Now, I guess in some way that is maybe the outlier, but for some individuals, it is really important to have that type of agreement because if they don't intend to be married, they just want to live together for whatever reason, it might be important to have that cohabitation agreement in place so that if something were to happen, the surviving individual does not come in and claim common law marriage and whatever rights and benefits they may be entitled to seek under law.
Well, thank you everyone again for joining us on Till Death Do Us Plan. Make sure to hit the like button. Make sure to subscribe to the podcast so you can be in tune on the latest when it comes to estate planning, when it comes to probate, trust, and guardianships. We have lots of great content coming up. You're not going to want to miss it. Thank you all for joining us, and we'll see you on the next one.